Nice.
There we are. There we are. Look at that handsome fella.
Look at the Handsome Devils. Yeah, Handsome Devils on the podcast. How are you doing today, Mr. Jeff Kaufman?
Oh, just your average Friday.
Friday fun day is like what we call it around here.
Yeah.
So yeah.
You know what, man? That's one thing that I've had a conversation with someone about this just last week. But I guess it's just a carryover from my from my W-2 days. I still look forward to the weekends, man. I just do. I mean, I haven't had a job in, I don't know, 6-7 years now. I just still look forward to the weekends. I think it's, initially I started that started because, just that's the way my family and a lot of my friends, they just all have the weekends off. But, I still look forward to, even though I usually end up working all weekend. I don't know about you, but I still look forward to it. It's weird. It's a psychological thing, I guess.
Well, it's embedded. It's ingrained on you when you're in school for 13 years from, kindergarten to senior in high school, and you always look forward to the weekends, and I like you can't hardly get it out of you. So
yeah. Not to mention being stuck in that prison for the last 20 years of the. I shouldn't say that. There's probably a lot of folks that are going to be watching that still have W-2. So I don't want to say that it's a bad thing, but. Ultimately the goal is to be the master of your own time, right?
Oh, shit. Yes. Yeah. 100%. So today I thought we would talk a little bit about land trusts.
Absolutely.
Is that all right with you? This is probably one of the most misunderstood, misused, underused item in the toolbox of real estate investors. Would you agree with that statement?
Man, it is not only is it not used, it's just completely misunderstood. I think people think it's really, really complicated, and it just doesn't have to be that way. And I think it's one of those things too, where once you finally understand what's going on inside one of these trusts, it is so simple. You're gonna kick yourself. You're really gonna kick yourself. You're gonna think, man, why wasn't I doing this all along? And I don't know about you. I've been using land trust now for about the past 5 years, and nearly every property that I buy, not all of them, but nearly all of them are all purchased in land trust now. It's one of the greatest. I like to call it the last kind of vestige of I don't know. It's the last great tool I think that we have as real estate investors. I just think they're super flexible and.
Well, why do you like it so much? So you started using it. So somebody convinced you, or you convinced yourself a few years ago. I've been using them probably. My first trust I did was probably, what are we, 10, 12 years ago. And so I've done a lot of work. Like there are some really masters. We say gurus a lot. I say masters. There are some really good masters of land trusts. I've been doing it for decades and decades. And so I finally just started going to and learning from the best of the guys. And then we've now taken it and made our own trust useful to us. But just to take a step back before we get in the details, you said land trusts can be very simple. Yes, they can be very complicated too. So let's try to keep it simple. Why do you use land trust? What was the main reason you started using land trust in your business?
Well, in one word, it would be flexibility. But if I had to break that down a little bit, I would say that when I first started implementing them, it was a little tough to understand, but once I started implementing it, I started finding these little, it's very hard to even give you an example right now because there's been so many of these examples, but I started finding like issues that I was having in the business, right? Like, I would have, maybe some weird title issue, or maybe something that, that I just thought, or maybe we're talking about liens. I just would find these little things that a land trust seemed to remedy. You could bring a solution through by using land trusts. And like I said, there's so many of those examples that it's really pin one down. But they are just so flexible. They're so flexible from anything from from private lending to preventing liens being put on properties. They're just so flexible. I love to sell. I love to sell properties. I love to sell beneficial ownership is what I like to sell. I don't really like to sell properties, but I mean, just I could give you one really, really great example of something that we did, and I learned this through doing some deals down in Texas. Did a couple deals down in Houston, and I used to be a lease option guy. I used to lease option. I'd buy a property, get it rehabbed, and then I would lease option it on the disposition side. And now I've since learned I'm kind of recovering from that. I mean, it was I don't like to do that anymore. It was too much like landlording. But one of the unique aspects of Texas is that in Texas, it's very, very hard to lease option a property. It can be done. It can totally be done. But I think the maintenance that is required if you're going to lease option a property to someone, you're probably just better off renting, So we knew we didn't want to do a lease option at this particular property in Houston. So I thought, well, let's just sell or finance it to someone, right? No problem. Up here, we do contract for deed all day long. No big deal. Guess what? Contract for deed in Texas they've really put the kibosh on that. It's almost non-existent down there.
It's pretty much gone.
Yeah. So I thought, well, how in the heck can we do this? Well, I started doing like you. I started doing a bunch of reading and really just trying to figure this thing out. And then I discovered this, inside a land trust. I thought, well, and we'll go over, I guess we'll go over kind of the high level stuff on the positions and stuff inside a land trust. But I'm just going to say I found out that beneficial ownership, or I realized that beneficial ownership is not, it's personal property. It's considered personal property.
Personal property, yep.
And so I thought, well, so is my car. My truck is personal property.
Yes, indeed.
If I wanted to sell my vehicle, I mean, I can totally do that on terms. I don't have to have, I don't have to sell my truck for cash. I don't have to do that. And so I thought, well, how in the world can I sell this quote personal property, this beneficial ownership? How can I do that inside this trust? And lo and behold, we end up getting the deal done. It can be a little bit scary, maybe, I guess, the first time you do it, but it's just like anything else. Once it's done, it becomes a tool in your toolbox. And today, in fact, you and I just sold a property over in Illinois using this exact strategy.
Inside the trust, right? We basically did a joint venture agreement. We created a promissory note inside the trust and did a joint venture agreement with another LLC. That's correct. Yep. See, now you said we were going to keep it simple, and now we're talking about all these advanced.
I know.
All these advanced here. Well, let's take it back a notch too, and just say why do I love trust? Well, as you're probably going to know if you start watching me and get to know my personality, I hate people being in my business. Like Big Brother is Jeff smiles at that. Is like, I can't stand it. The purpose of government is safety, security, infrastructure, and to have a fair and balanced playing field in the economy. It's not to regulate anything. It's not to tell me what to do. It's not to sit here and give me new friggin' guidelines in the Corporate Transparency Act. None of the above. It is, right? So anyway, sorry. Soapbox. I'm going to step down off the soapbox now.
I've never heard you say this stuff, by the way. This is the first time hearing this.
The reason why I love land trust is privacy, privacy, privacy. All that stuff that we just described that we did, it's inside the trust, right? It's nobody's business. There's nothing being recorded outside of the warranty deed that says the trust holds the property, if we're talking about a piece of real estate. But all this stuff is private inside the trust, right? That's why I love using trust. The privacy, the ease, the flexibility. You said you can do everything inside the trust that you can do outside of a trust, right? If you want to do a wrap mortgage, right? We can do that with a trust just as well as we can do that with personal people or LLCs or any of these. A trust is just an entity. It's another entity, right? It's a tool we use, right? But let's be clear though. There's lots of different types of trust. We're talking about here land trust. Land trust is a revocable type trust, right? There's revocable and irrevocable. And when you take a revocable trust and you put a piece of real estate in it, by definition, it's a land trust. You never have
Or
to
you
use the word
fund
land.
it. Yeah. Yeah. You fund it with a piece of real estate. That's how
Yes.
it's funded.
Yes. You
Yeah.
put the asset, the type of trust is dependent on the asset that's in there, right?
Right.
So if it's a piece of real estate, then by definition, it's a land trust. And you never have to use the term land, right? Pro tip, right? Just one of our pro tips. And when we talk about trust, pro tip is, hey, if the title company looks at you funny by wanting to do something with the trust, just don't say it's a land trust. Just say it's a revocable trust. And they understand that for estate planning purposes, right? Living trusts are revocable trust as well. They understand that. So just use that as a
Yeah.
pro tip.
I actually had I had got one of my trusts kicked back to me one time. This is really early on, which they very rarely do. But I had an attorney. The attorney, and again, this was a mistake that I had made. I allowed one of my buyers to actually close at their title company, and I say that I've since learned not to do that, but every
Yes.
great once in a while I break my own rule.
Yes.
So,
Yep.
but I actually had so this attorney reviewed this trust and immediately kicked it back. Just kicked it back. Said, nope, that's a land trust, and in Missouri we don't have a statute for a land trust.
Yep.
So, and like many states don't. So, I got a kickback. I had to kind of go out and have it revised, and make them happy. Basically, just make them happy. And the lesson there is to use your own title company at all costs.
Yes. Control the transaction. Yeah. Control it start to finish. That's right.
Yeah.
But going back to the trust too, like, so what's the reason you want to use a trust? Most people know of trust for estate planning purposes, and it avoids probate and all that stuff. All that's good and well. But for our purposes in real estate, we just mentioned we like the privacy. We like the ability to do things inside the trust without anybody monitoring it, right? And our trust, our land trust, are flow through entities. So it's the beneficiary of the trust that actually has the tax consequence, right? The whole purpose. Let's go back. We probably didn't even say this. What the hell is a trust? The whole purpose of a trust is to hold a piece of property, whether that's real property or personal property, for the benefit of the named beneficiaries, right? That's the whole reason to establish a trust, regardless of what kind of trust it is. So the whole reason to make a land trust is simply to have that piece of property benefit the beneficiary, which is what? Our LLC or another trust or whatever, whoever the beneficiaries that you deem appropriate, right? So that's the whole purpose of the trust. That's why we like the trust. It's an entity we control without actually being on title.
All right. See, you've done it too. See this? It's super hard to talk about these trusts without really getting into them. So why don't we break down the parties to a trust? Let's do this first. So we understand that a trust is designed for a third party to hold on to assets for the benefit of another party.
Yep.
So for example, when a trust is created, or there's a grantor that creates a trust, what that individual is doing is they are selecting what's called a trustee, the trustee of the trust. That is the person that is actually going to take title to the property. They actually, quote, own. I'll say own. They don't really own it. The trust owns it. Yes. But they are the dutiful. What do you call it? The dutiful. What's the word I'm looking for?
They're the arbiter of what happens with the property.
Correct. Right.
So they do transactional stuff as it relates to the property on the direction of the beneficiary or a trust director, but for simple terms, on the direction of the beneficiary, right?
So, so we've got the trustee. The trustee's taking title to the property in a land trust. The other party, we're not going to talk about the director part yet.
No, that's an advanced thing. Sorry.
Director has there's a few implications with the director as well. The trustee is holding title to that property for the benefit of the beneficiary or beneficiaries. And so the question then becomes, well, the question that I get a lot is, well, who do you select as your trustee?
Yeah.
Who is going to be your trustee?
Yep.
And for my purposes, I like to have an individual, a person, a real life human being, be the trustee of my trust. I just like it that way. There's less confusion. You don't have to have let's just go back. You have the option of selecting. There are many LLCs out there, or many companies. There's law firms and all kinds of people that people select as their trustee.
Yeah. Corporate trustees.
Trustees, correct.
Yep.
I like an individual trustee. Now, if we can select a corporate trustee at a later date, and I'm going to go down the rabbit hole here, but let's say that you are, you're quoted. I don't know. You have to. Well, let's look at foreclosures. It's the same sort of thing, right? We have a deed of trust which is recorded. That deed of trust is it's similar. A lot of people think that they own their property when they get a mortgage put on. They do not own it.
No.
They don't own it. There's a deed of trust that is recorded. Now you're the legal title holder, but you don't own that property. The trustee named in the deed of trust that's recorded actually owns that property. And so what ends up happening is, if you don't make your payments and the bank has to foreclose, they are usually going to appoint a successor trustee, someone who can manage the foreclosure of that property. And so I'm just trying to make a comparison so that you understand, so that the audience understands, that the trustee is kind of they're the referee there. They're the ones that are actually taking the actions.
Yep.
Now, but those actions are taken on behalf of the beneficiary.
Yep.
So what I like to say a trustee's job is just to sign documents.
Yep.
That's it. It's real simple.
When they're told to.
When they're told to. Right.
At the direction of the beneficiaries. That's right. Yep.
Right. So so then what is the benefit of being a beneficiary? That's a question for you.
For me?
Yep.
What's my benefit?
Yes.
Well, the number one thing is privacy. So the trustee is also the face of the trust, so to speak. Mm-hmm. It's what not in every jurisdiction, but many jurisdictions require the trustee's name to be recorded, publicly recorded, so that they know who to contact if there were issues with the property. So me as the beneficiary, I am actually in control of the trust as the beneficiary. I tell the trustee what to do and when to do it, right? Go close the property, go sign this management agreement, whatever the case may be. Like I'm directing that, but no one ever knows that, right? So that's the benefit to me. And then the trust, remember the whole point of the trust is to provide me the benefits of the piece of real estate. So that means the rental income.
That's where I was going with this. It's kind of a trick question, but that's
it all comes to me. It doesn't go to the trustee. The trustee has no ability or say in any of that. It's a flow through entity, right? Our land trust is a flow through entity directly to the beneficiary, which also means the beneficiary has a tax consequence on it. But the trustee is just the name out in front that's doing and signing things per the direction of the beneficiary, which is reaping all the rewards. Right? We keep saying benefits, so it's like it's a hard word. It's a hard synonym to come up with. Right? It's for the benefit of the beneficiary, right? So a lot of terms in there too. But we're reaping the rewards as the beneficiary. So that's why I love to be beneficiary, all over the place, everywhere. So
and so who's eligible to be a beneficiary?
Well, typically if we're talking about just structuring it, wait, well, let's go back before we talk about beneficiaries. Let's go back and talk about the trustee and selecting the trustee. You mentioned we don't like using corporate trustees. Like, we use each other as trustees. We're trustees when for some of our students in there and other investors and all of that. The trustee can also be a different family member, a different whatever the case may be. But just remember that could be going on public record. So if your brother, my brother's name's Roger, so if Roger Rossix goes on public record, it might not really be that private anymore. So just keep those things in mind. But then maybe I want to use my brother because he lives in Alabama. And let's say the property is in Missouri. And now in order to have suit against the trust, they have to serve notice on the trustee, which is in Alabama. Sorry, I'm getting advanced again. But just so there's lots of things to consider when selecting the trustee, but it needs to be somebody that's not going to screw you over, right? Because the trustee could just go in there and redeed the property. The trustee could quit claim the property over to their personal name or whatever. That could happen and likely does, right? So it's important to choose the trustee so that won't happen. And the trustee is only doing things you tell them to do when you tell them to do it.
Yeah. Reliable, integrity, has integrity. And
what's that mean nowadays, Jeff? Integrity. Sorry, separate. That's a separate podcast. Yeah.
I'm trying to tell you, you are on it today, man.
I am on fire. Yeah. I've just been, as I told Jeff earlier too, so I'm just going to digress for a second. Like, can we just chat just for a second? Like, I'm going to go off the topic of land trust and just say that when you enter into an agreement with a company, one expects that company to honor said agreement. Like, I'm not asking for the moon, the sky, and the stars. I just want the agreement to be honored. And when they don't, and I don't even get any communication, that pisses me off. So sorry. That's why I'm on fire today, just so you know, because that happened earlier. Anyway, I think we've got that resolved. So land trust. Now let's edit back. Sorry, personal commercial. Now we'll edit back to the land trust. So now we have a trustee, parties to the trust. Sorry, trustee, beneficiaries, and you mentioned this too. But the third party is the person who creates the trust, the grantor, the settlor, the trust creator, whatever you want to call them. And typically that's going to be the beneficiary too for our purposes when we use land trust. So those are the three parties to the trust. So let's talk a little bit more about the beneficiary. How do you set your beneficiaries up, right? We mentioned it's typically our LLC. So I assume that's probably most of the way you set it up. But how do you set your beneficiaries up? Do you do anything special or particular?
Well, do you want the long-winded story or do you want you just want a short answer? I'll go somewhere in between. So when I first started in this business, when I first got into this business, I was using LLCs. So I do a lot of subject to deals. And the general rule of thumb for subject to deals is, one subject to deal, one bank account, one company. So I would create an LLC for every single subject to deal that I did. Well, that's fine and good, and it works well. You can sell the LLC. You can, there's a lot of things you can do by doing that. It makes accounting really simple because you just have one bank account. You can show the income and the expenditures out of that one account. It's super simple. Taxes are simple. The problem is that, and if my wife were sitting here, she'd be shaking her head.
I'll shake my head for her.
So the first subject to deal I bought, it was actually the first few that I bought. I created new LLCs for, and I'm just going to be honest. I wasn't the best about taxes. I was terrible with taxes. And so I actually didn't get my first tax returns or my taxes as a quote new business. I didn't get them done until 2018. Now I bought the first properties in 2016. So I was a year behind on taxes. Lo and behold, in Missouri, I did not know this. So this was a huge lesson. In Missouri, if you create a Missouri LLC, and this is the same, there's a lot of states that do the exact same thing. So you got to be careful. You must file a return on every single Missouri LLC.
Mm-hmm. Right.
If you create an LLC in Missouri, you must file a return on it.
Yep.
Well, guess what? At the end of 2 years, I had 22 different LLCs. Each one of those tax returns had to be filed separately. We had to link all them back to the owner, which the owner of the owner of each one of those LLCs was one other LLC. So, I mean, I just had EINs everywhere. It was just a nightmare. It was a total nightmare. So I just thought, man, how am I I got to simplify my life if I'm going to continue to do this. And so that's when the trusts really started coming in. That's actually why I really started using trust, because it is a much simpler process. And I tell everybody, I don't know if you can see behind me where my thumb is here. There's my printer back there.
Yes.
However much it cost me for toner and 13 pages of trust documents, that's how easy it is to create a trust now. And that's how much it cost me. So to answer your question, I have two LLCs, but only one of those I use as the beneficiary in my trusts.
Your buy and hold LLC.
My buy and hold LLC. If I'm going to buy and hold a property in a trust, I use that one single LLC. And since the day I decided to do that, my life has been, outside of other issues, my life has been great when it comes to real estate. Yeah. Everybody's got a perfect life. I don't care what.
Yes. The one LLC for that. That's an important point though. The one LLC per property sounds good. It's a good thing that gurus tell you to do, but depending on your state, or that could be a whole lot more cumbersome than you think it is. So it's so much easier to have one trust for one property and then have an LLC or two that you can use as the beneficiaries in there.
Yeah.
Which is the way we do it. Right.
And not to mention, if we're talking about taxes, so I guess we got to clear this up too. If you're going to have a bank account with an LLC, you've got to have an EIN. So what does that do? I mean, I just look at an LLC. It's more of an agreement with the state than it is anything else. And so that, to me, that is just so exposing, where a land trust, 9 times out of 10, well, 10 times out of 10, they don't even know who the beneficiary is.
Correct. Private.
So,
private.
It's just a trust is a much simpler. If you're out there wanting to simplify your business and you're in real estate, I just highly recommend that you learn how a trust works and the rules and kind of the I wanted to say restrictions, but there really are very few restrictions as it relates to trusts.
There are a couple limitations though.
There are. Yeah.
But I just want to talk a little bit more about this issue with the trust, because what you just said goes right along with what I mentioned earlier, the Corporate Transparency Act. Mm-hmm. So let's just spend a moment talking about that, because some people that have real estate LLCs have never even heard that maybe before right now, or maybe heard it and it's like, oh, okay, well, it's coming later. So the Corporate Transparency Act was passed by the U.S. government in 2019. It went into force January 1st, 2024. So any new business entity, including LLCs for real estate purposes, that are filed in any state of the union after January 1st, 2024, has to file the beneficial information of the LLC. So what does that mean? The owners of the LLC has to be filed on record with the U.S. government. That's what
the federal government, which, by the way, there is no such thing as a federal LLC. Doesn't exist.
Right.
So the LLCs are created on a state by state basis. They each have their own rules and regulations and statutes behind those LLCs. But the federal government has nothing to do other than they look at an LLC as what they call a disregarded entity. And so they don't really acknowledge LLCs except for when they want to know your business, right? I mean, like, it's just nuts. It's just crazy.
Right. Well, the Corporate Transparency Act is supposedly, I'm using air quotes that are fading in and out. I apologize. I'm not high tech here. Are fading in and out because the Corporate Transparency Act is supposed to prevent fraud, money laundering, et cetera, et cetera. Except, of course, the people doing the actual money laundering and fraud are typically financially related in financial institutions or they're a financial advisor, or they're somehow tied to that. And those sons of bitches are exempt from the Corporate Transparency Act, mind you.
Yeah.
So who is it really targeted to, one might ask? Well, if one was a conspiracy theorist, they'd probably say you and me. Well, you'd be right. You and the 86,000 new IRS agents would be correct in assuming that they're targeting us. So there is a lot. The good news is there is a lot of, the reporting requirements. You have to report to, and every existing LLC that was filed prior to January 1st, 2024 has to report by January 1st, 2025, by the way. So you don't get a grandfather exemption. You just have to do it 1 year later, right? So all those states, the reason sometimes we have an LLC, like Jeff and I have a Wyoming LLC. Why did we put it in Wyoming, Jeff? Because it's a great state for privacy protection for LLCs, for liability protection, privacy protection, all their laws. It's a great place to do that. So now this Corporate Transparency Act has basically told Wyoming, we don't give a shit about your laws. We're gonna have this reporting requirement anyway. Yep. So it's interesting. It's very interesting. Yeah. By the way, there are numerous lawsuits against the constitutionality of the Corporate Transparency Act. And just like you said, like the government doesn't have the authority necessarily to tell the individual states how to do their LLC, how to govern their laws as it relates to businesses, business entities, and LLCs. So there's lots of litigation out there. However, things are still proceeding at the moment. So there'll be a lot more to come on that. But one of the reasons, one of the reasons to use the trust is because there's no Corporate Trust Act, at least. And so all that stuff is still private. That's another reason to start using land trust in your business if you have not already done so or would like to ratchet it up a notch. That's the main reason, my opinion.
Yeah. Not to mention we didn't even talk about the penalties. The penalties for at least today, at least right now. Yes, there are tons of lawsuits out there on this thing, but the penalty today is up to $500 per day.
Per day.
If you do not file or record, whatever they call that.
Yes,
if you do not record, file your LLC in accordance with this new law, up to $500 per day. It's outrageous. It's unreal.
But, yeah, it's the BOI report, by the way. It's the beneficial ownership information. And when they say, again, so now they even use the word beneficial here. They're saying it in context as to who owns the business. And it's not just LLCs. It's all, there's many different business entities. But there are 23 exemptions. And it was just curious how many of the exemptions are probably the people that are actually doing the money laundering, but whatever. Hey, it's all good. So just real quick here, you mentioned that we like to do subject to deals, right, inside the trust. Why are trusts good vehicles for specifically subject to deals, Jeff?
Well, oh boy, this is really going to get down the
rabbit
hole. This was supposed to be a half hour long.
We're almost there.
Okay. So first of all, I'm not an attorney. Ken's not an attorney. Basically, we know attorneys, but that's the limit of our legal profession, right? So, but I will say, subject to deals, inside trust, particularly, if you're going to be doing subject to deals, you want to prefer the trust over the LLC method all day long, and so I guess if we're going to divide this up between the LLC method and the trust method, the Fannie actually does have guidelines now for properties that are transferred into LLCs. They do allow it. That's not widely known, by the way. A lot of people don't know that, but it's very, very common for investors to buy some properties and transfer those properties into an LLC. And so Fannie gives them a break for that. I can't cite the exact chapter and all that good stuff.
Yeah, that's the regulation. Yeah.
But they do allow it. That being said, if you're doing a subject to deal, there's another party involved, and that party is called the bank. It's called the lender. the seller's lender.
Right.
And so we have what's called the due on sale clause, where they will accelerate, or they can. And this was a big thing back in the 80s, and I'll tell you why in a second. But what they can do, what a lender can do, is if a property is transferred if a property is transferred into another entity or to another individual, that loan is to be paid off, and you're going to find this information in the deed of trust, right? So if the property is transferred without that loan being paid off, they have the option. It's just an option. They have the option of calling that note due or accelerating that loan. Now, with a subject to deal, that's all we do. We transfer properties, we leave a loan in place, and we transfer that property into another entity. In our case, it's going to be a trust. So one of the reasons that we like to use trusts is because properties are transferred into trusts all day long for, I'm going to call it estate planning purposes. They're transferred every single day. It's probably one happening right now, probably 1,000 of them happening right now. It's so common. The difference here is that whoever controls that trust, who is the beneficiary of that trust, is going to be different from the seller. And so there's a law out there. It's in 1982, the Garn-St. Germain Act of 1982 came into play, because if you recall, back in the 80s, interest rates jumped up to as high as like 18%. It was just insane. It was super, super predatory. Everybody knew it was predatory. The government knew it was predatory. So the Garn-St. Germain Act came into play. And essentially what that is, the Garn-St. Germain Act, is it provides, there's a ton of verbiage in it. So I'm going to talk about the particular statute, or the particular part of the Garn-St. Germain Act that applies to us. Garn-St. Germain Act, there are 9 exemptions. Do I have that mixed up? No, there are 9 exemptions to a lender calling a note due. One of those happens to be transferring a property into a trust. And so there's a lot of people out there that teach that if you transfer your property into a trust, or in our case, if we transfer a property that we bought subject to into a trust, that somehow the Garn-St. Germain Act somehow protects us. And it absolutely does not. It does not protect you at all. And quite frankly, should a lender ever get a hold of your trust documents, and they can see that the beneficiary, which should be, according to them, the person named on the mortgage, that should be the beneficiary of that trust, they see that beneficiary has changed to someone else, they do have the right to call that, to accelerate that loan and call that note due. So where are we going with this? I've got so far down the rabbit hole that I've already talked myself out of my.
And yeah, the Garn-St. Germain Act, you could look that up too. But I think that the point is that there's an exemption specifically for trusts.
There
now,
is.
I believe in that act, though, they're probably talking more about a living trust, but they don't define that. So
correct.
Again, a trust, right? It's a revocable trust. A living trust is a revocable trust, just like a land trust is. And the only thing that makes ours different is that we're funding, therefore it's a land. I think that is the purpose, because when the lender sees that we're putting a property into trust for, as you mentioned, estate planning purposes, like the air quotes in there, they see that all day, like you said, they see that all day long. And so it doesn't raise red flags. Correct. We are just in the business of keeping the red flags down and doing the right thing, right? We conduct our business with integrity. So anybody that's a party to our trusts, we treat like that, and we make sure that the lender continues to get paid. As long as the lender continues to get paid 99,999 times out of 10,000, they're not even going to worry about it, because their income stream is continuing to come in. But you can send red flags up if you start doing transfers in the wrong way, or especially if you mess with the insurance, that sends a red flag and it's escrowed, right? So that's why using a trust is beneficial in there to
Yeah. I
sum
like to
that up
say,
together.
it's a little bit of smoke and mirrors, but I'm going to tell you this. I have, every subject to deal I do, I get a power of attorney from the seller, and every single one every lender I've ever talked to, I mean, they know. In fact, I know a mortgage lender here locally in St. Louis that, I mean, I've talked to him about this before many times. In fact, I'm going to be speaking in October at the Gateway to Freedom. So if there's anybody here locally, go out and get your ticket. I don't have a code yet. I'm supposed to get a code because we're having this little competition about who can bring in the most guests.
Oh, yes, yes.
So maybe I'll bring that up again next time. But I've talked to this lender many times. In fact, he's actually at the last Gateway to Freedom, the last one I spoke at. He's like, you guys, wait till you hear about this subject to stuff. He was super excited about it. He's a lender. This is what they do. So they know. I've been on the phone with many lenders. They know what's going on. The reality is they are genuinely. I like to say they have two columns in their ledger, right? They have a performing and a non-performing column.
Right.
As long as that loan shows up in that performing column, 99.9% of the time, they're happy as can be. They've got investors too. So you got to understand, for the most part, which actually can be a little misleading too, because most of these companies sell those notes off to Fannie. They sell them to the secondary market.
Right. Yeah.
But they do know. I mean, don't even kid yourself. But the fact that that note is performing keeps the powers that be happy, and it's what allows us to do more and more subject to deals. And I will probably never stop doing subject to deals.
Yep.
Because I mean, it's just such a fantastic way to buy.
And I think on that note, let's just wrap it up. We just gave a little overview about trust in there, so you can see maybe in the scrolling bar down there, we're going to have a new land trust course coming available here, hopefully in the next week or so. So check back to our website often. Jeff mentioned we talked a little bit about the subject to, right? We're Sub 2 Empire. We've got great Sub 2 documents. Go check those out as well. And we will see you in the next episode.
That's right, guys. Take care. We'll see you. I got to figure out how to end this stream now. All right, there we go. Take care, guys.